The legal interpretation could change if specific facts are provided. So this also does not create an attorney-client relationship. Again, we're providing some general advice and information and informational purposes. Please follow up with your counsel or us if you have any specific fact questions. Please also don't disclose any specific facts as it relates to your company when you're asking questions, as that could end up disclosing confidential or private information that you don't want to disclose. So with that, we're going to start off with information about employment practices liability insurance. And we're going to provide that discussion through Adam Busler. So Adam, go ahead and take it away.
Hey, good afternoon, everyone. I'm going to start us off with the exciting topic on EPLI, Employment Practices Liability Insurance. And this is a particular type of insurance that protects your business against employment-related lawsuits. And that ranges for anything from, discrimination, harassment, wrongful termination, to retaliation claims and work whistleblower claims. But it also can protect you from, failure to hire claims. So it could work. It could protect the business from not only current employees or former employees, but also applicants who were not even hired. Next slide, please. So why does it matter? If you've ever been involved with litigation or if you've ever been sued before, you'll know that legal costs add up very quickly. And I see this with clients all the time, even claims that are completely baseless and we have great defenses to them, it could still cost the client tens of thousands of dollars in attorney's fees just to prove that you didn't do anything wrong. Small businesses are particularly vulnerable to these types of claims because they typically do not have a dedicated HR team to document these issues as they arise, or in-house counsel to provide guidance when there are problems. So it makes, I think, even more sense in the small business context to make sure that the business is protected and your livelihood's protected by getting EPLI. New Jersey, if you haven't noticed, is a very the laws governing employment relationships are tilted in favor of the employees. As a result, we see tons of employment claims like these filed every day throughout the state. To make it more complicated, everyone has a computer or a smartphone. They can Google things. They can use ChatGPT. So there's a much higher level of employee awareness in terms of what their rights are under the law than what we saw maybe 10, 12 years ago. And for that reason too, we think that is part of why there's so many of these claims being filed now. So I mean, the bottom line is, getting an EPLI policy, which can oftentimes be a rider to your existing business insurance package, they're not that expensive and they can give you peace of mind and financial protection. I tell my clients this frequently is if you have a substantial workforce, 10 plus employees, and you're going to be operating for a while, it's not really a matter of if you're going to get sued for one of these claims. It's a matter of when. And in our view, the best way to protect the business and protect yourselves is to get this EPLI policy in place so that when a case does arise with an employee or a potential employee or former employee, the business is sufficiently protected so that you have insurance coverage to cover the legal fees and, if there is an adverse judgment or to pay for a settlement. It makes financial sense to explore these policies.
Thanks, Adam. And with that, we're going to turn to the topic of managing employees. One of our favorite things to do is to help clients avoid getting sued. And there are some really simple steps that you can take in terms of managing your employees that could help you avoid litigation and create a better work environment, even for retention of your employees. So with that, I'll turn it over to Lauren to talk about this topic.
Sure. Thank you. Good afternoon, everyone. So I'm just going to give some tips for managing employees. First is follow internal procedures. So many small businesses have these internal policies and procedures, maybe they're not in writing, but they need to be followed across the board. So all of your employees, including, management all the way down to, line level employees, should be following these policies across the board. If you're going to have a policy, you have to enforce it. So don't have policies if you're not going to enforce them or enforce them uniformly, because that can lead to litigation down the line. Why was X employee punished for this, but Y employee was not? So those need to be followed uniformly, or it leads to employees believing that there is another reason for that policy enforcement. Also, be positive, be friendly. The more positive and friendly that you are, the more employee morale is going to go up, and you're going to have people who want to work for your business and continue working for your business. What friendly doesn't mean. So you don't have to be an employee's best friend. You don't need to forgive bad performance. You don't need to get involved in personal problems or invite subordinates to your home, lending them money, or letting them do what they want. But it does mean being respectful, saying please and thank you, looking at people's faces when they talk to you, greeting people, treating people who come into office as guests, and being polite and approachable. This leads to, employees thinking that they're respected, they are, valued as employees, and then they're going to continue to want to stay in your business. And then you're also going to avoid litigation in that end. It does mean not insulting people, holding conversations with people instead of lecturing, not looking at your phone when they're talking to you, controlling emotional outbursts, and controlling abusive conduct. So this goes back to the policies and procedures. Almost every business has a policy regarding, certain types of conduct. Those policies need to be followed throughout the board. And then the treatment of employees. Morale, it's needed for happy employees who are loyal and productive. Respect, treat employees with dignity and courtesy as if they were a member of the public or one of your customers, and foster a respectful work environment.
Thank you so much, Lauren. So now we're going to talk a little bit about performance reviews. Jane gave in the introduction a little information about, we're going to talk about documenting employee performance or documenting issues regarding employees. And we're going to talk to you a little bit about how performance reviews can help or hurt you if they're not done properly. And with that, I'll turn it over to Adam.
Thanks, Eileen. So performance reviews. Well, before I touch on performance reviews, I just want to emphasize the importance of documenting issues with your employees. The old saying, if it's not in writing, it didn't happen, applies, I think, with the utmost force in this situation. And one of the best ways to document employee issues or their performance would be through a regular performance review process for your employees. And the issue is that these performance review policies can operate as a sword and a shield when you get into litigation. But there are also times, and Eileen and Lauren would agree with this, because I know they've seen it as well, because we've had it on cases we work together, where they can actually be a complete catastrophe and can really undermine your defenses if you're sued by an employee. The best practice when you have a formal performance review policy is to have, their schedule on regular intervals, and the management employees or yourselves who are conducting these reviews do so in a way that accurately reflects the employee's performance, and they're honest in the feedback that they provide. And this serves two purposes, right? One, there's transparency. The employees know exactly where they stand. They know what they need to work on, what they're doing well, and it can lead to better employment outcomes for these employees. On the other hand, when they're not accurate, when you have managers who are saying satisfactory to every different criteria, or everything's great, and then you have a situation where you need to terminate someone because they're having performance issues. And I have had clients do this. Clients do this to me all the time. They tell me, this person's a terrible employee. I want to fire them. I'm like, oh, okay, great. Let me see their performance reviews. And they'll send them to me. And if you read just the performance reviews, these employees would look like they're the best employees you've ever seen. And I'll ask them about them. And almost every single time I get it, well, this isn't right. This isn't accurate. They really stink at their job, but we didn't want to hurt anyone's feelings. So, we said they were doing a great job. The problem with that is, if that's our reason for terminating the employee, if they were terminated due to poor performance, they file a lawsuit claiming that they were terminated due to, name any protected class you want, age, race, gender, sexual orientation. And we say, well, they were fired for poor performance. We produce those performance reviews and discovery. It makes us look like the client's lying, right? And that the performance could not have been the reason for the termination. And it makes the case significantly harder to defend. So the best outcome, or the best approach to this, is if you're going to do performance reviews, make sure that they're being done accurately. There's a formal system for how you do them, and that your managers are trained in a way so they understand the importance of these reviews, and making sure that they accurately reflect the employee's performance. If you have a performance review policy in place, but it's not being taken seriously, it's almost better just to not have a formal review process and just document issues as they go. Because the worst thing we can have is a formal review process where the reviews themselves do not accurately reflect the performance of the employees. Slide, please.
Yeah, thank you, Adam. I mean, that is, I echo everything that Adam has said. We've told clients on numerous occasions, if you're not going to have the courage to be honest in the performance evaluations, don't do them. Because, being soft on providing that feedback and not giving the employee the privilege of knowing that they have a problem so they can correct it is going to come back to bite you later. So, sometimes these things don't have to be super formal. It can be an email. Great job on the following project, or, we received your information or your first attempt at that project and it didn't really meet the standards we were looking for. We need you to correct it in the following way. Or you've been late on 5 different occasions. We need to see immediate change, or we're going to need to take adverse employment action against you. I mean, sometimes it can be easy to document this information, but it really is important, as Adam indicated, to make sure you're documenting things accurately. So with that, we're going to move on to leaves of absence, unless anybody has any questions on what we've covered so far. We can see the chat, so if you want to put it in the chat, that's fine, or you could message Jane or Debbie directly, and they could feed it to us. I don't see any questions, so we'll move on to leave of absence and hopefully hold some time at the end for questions. Now, leaves of absence are difficult. I can't really mince words on this issue. When an employee is absent from work, there's a lot of different factors that cross over one another and a lot of different things that you need to consider. There are statutory compensation entitlements in New Jersey where people get paid leave. So there's temporary disability insurance, there's workers' comp insurance, there's the New Jersey family leave, paid leave under the New Jersey FLI. So there is some significant compensation entitlements for employees if they are going to be out of work. And I'm sure all of you have had to deal with that in terms of your employees either being injured on the job or becoming disabled for some reason unrelated to a work-related injury. So these are all issues that I'm sure you've had to deal with in the past. And the New Jersey Department of Labor website has some really great, helpful, free information for employers about those types of leaves. There's also different unpaid statutory leave entitlements, like the Family Medical Leave Act, the federal statute, and the New Jersey Family Leave Act. We also have the New Jersey Earned Sick Leave, which is paid. That's a paid statutory leave entitlement that was enacted not that long ago. But you also have your internal policies. You know, you have your employee handbooks, your manuals, any kind of labor agreement if you happen to have union-related employees, and your internal policies, rules, procedures, and the posters that you're required to post in your common area for your employees for both federal and state notice requirements. So you need to follow all of that in terms of how you deal with absences from work. And as Lauren had indicated earlier in the presentation, you need to make sure that you treat everyone the same. You know, if you treat an absence from work for an employee differently, based on some criteria that's not identified and is not legal, you could be subject to a lawsuit as a result. There's also certain types of reasonable accommodations that include leaves of absence. So oftentimes our clients will come to us, or new clients will come to us and say, well, they exhausted all of their leave and they still needed some additional time off. Well, under the Americans with Disabilities Act and the New Jersey law against discrimination and some other federal statutes, one of the reasonable accommodations that you may need to consider is additional time off, even if it's unpaid. So you have to engage in the interactive process with the employee to see if it would be feasible for you to do that and whether or not it would be an undue hardship on the organization. And that's a very fact-specific inquiry that you need to handle differently depending on the position and what maybe the business needs are at the time of your particular organization. You also need to consider what similarly situated employees have had. This first question I always ask to clients when they ask me, I say, well, what have you done in the past? If someone has had this issue in the past, have you given them extended time? Have you given them this additional unpaid leave or time off? And maybe you don't want to do it for this individual. Why not if you've done it before? So again, I throw this chart up there because there's a lot of things to consider when you're deciding whether or not to allow someone to have a leave of absence from work. It's not always a black and white issue. You have to consider whether or not the leave should be paid or unpaid and whether or not an accommodation would be appropriate, which would include additional time off from work. So, please look at these requests and absences by your employees carefully to make sure that you don't run afoul of all of the different statutes and laws and regulations that we just mentioned and your internal policies. You want to make sure you're following those, clearly and directly. Does anyone have any general questions about leaves of absence? You can always reach out to us separately if you have a fact-specific question. Then I'm going to turn it over to Adam to talk about the termination. Oh, actually, I'm doing termination of employees. Sorry about that. So I'm going to do termination of employees or employment termination. We're not murdering our employees. We're just terminating their employment. But we're going to let Lauren talk to you a little bit first about at-will employment, because that's kind of the foundational element for a lot of the employment-related decisions we have here in New Jersey. We want to make sure that you understand that concept before we talk about separating an employee.
Sure. So New Jersey is an at-will employment state, but what does that actually mean? That means in the absence of some sort of employment contract that you can terminate an employee for cause or no cause at all. However, what it doesn't mean that you can terminate an employee for some sort of discriminatory reason. So you obviously can't take a discriminatory intent when you determine to fire or terminate an employee.
So with that as our backdrop, yes, because people say to us all the time when they come to us, oh, we're at that, my employees are at will, I can fire them whenever I want. You need to be really careful that, for example, if you have a handbook if you don't have a proper disclaimer in your handbook saying that handbook doesn't create a contract, you might not be an at-will employer. So please be careful with how you deal with this at-will employment concept. So you have an employee, the employee is a problem. You feel like maybe you want to separate that employee and let them go. Let's talk about what needs to be done before you take that step, that final step. You want to make sure you fully investigate all the relevant facts before the termination of an employee. Don't make like a knee-jerk decision. I just want this person out of here. I'm going to tell them to pack up their stuff and get out. It might feel like that's what you want to happen, but you really want to make sure you have all your ducks in a row and that you have all of the facts. So you want to make sure that you document the investigation. And Adam mentioned that earlier. We've been talking a little bit about how to document. You want to memorialize all the facts that led to the discipline. If you need to, obtain witness statements from either other employees or if there were other witnesses. Sometimes it's difficult, but there might have been a customer involved and you might need to get a customer or client information written down. But you want to make sure you complete all this documentation as soon as possible. What we have seen time and time again is that the employee is not dumb. They know that they're in trouble. They know that maybe the axe is about to drop. And they may do something between their poor performance or their misconduct and your decision to terminate their employment. They might make up some whistleblowing activity and report something that they know is not true or something that they think might be happening in a chance to save themselves. So you want to try to keep that timing as tight as possible. Some clients, and we do recommend this sometime, that you suspend the employee pending the investigation. I typically would say if you could always suspend them with pay, then they're not really having any type of adverse action. You're just kind of you've made them known that you've made it known to them that they've done something that is unacceptable and you're going to look into it in more detail. Please keep all the investigations confidential. If you're chatting too much with people about it and you're spreading this information, it could negatively impact the integrity of your investigation. So you want to make sure that you do not share information with people that don't need to know it, and be sure to keep it as confidential as possible. We talked about this before, why to document the discipline, to make sure that you memorialize the facts that are the basis for the separation of this employee. You may need it later if they sue you, but it also demonstrates to the employee that you've taken objective action. So when you're documenting, you want to think to yourself, what needs to be in here? I want the who, what, where, and when. Who was involved? What happened? Where did it happen? When did it happen? You want to make sure you document all those details. Make sure you review it after you've typed it up or after you've prepared it. You want to remove any judgment. You don't want to have any judgmental statements in there. Just be very specific and focus on the objective factors. Remove subjective statements and personal feelings that you may have about any of the people involved in the particular conduct that is the subject of this employment action. And then ask yourself, step back from the situation and ask, is the action reasonable? Is it objective? Is it given with proper notice? Is it supported by documentation? And is it justified? And when we talk about objective, you want to look back and see, what have we done before? Have we ever had this type of situation arise in the past? And what, if any, action have we taken in the past? Finally, once you're done all of that, you're ready to meet with the employee and tell them that their employment is being terminated. Sometimes you can't do that in person. It needs to be done in writing. But if you're doing it in person, you want to be careful about where the location is. You don't want to have this on display for, to embarrass the employee. You want to make sure that you're having it in a private location so that the employee isn't embarrassed. Sometimes they could have a knee-jerk reaction to file a lawsuit or take action if they feel like they've had, been paraded through and walked out in front of everybody. You want to try to keep that in mind when you are separating an employee. You want to make sure that you have a witness to the separation. So you have the employee with you. You're meeting with the employee, but you want to make sure that you also have another witness, someone who can witness exactly what was said and how it is being handled. You want to provide an explanation, but don't go into a whole detailed, long discussion and negotiation with the employee about what is happening. You just say to them, you violated this policy when the following things happened. That is something that you should say to them so that they don't jump to the conclusion that their termination is as a result of a protected classification. The written
I'm sorry, we have a question in the chat and I thought it was the appropriate time for it. It was asked, what should be included in a written confirmation?
Yep, that's my next topic. So in the written confirmation, you can say your employment has been terminated effective X date. You can say your employment was terminated for misconduct, for, unexcused absences. Whatever the specific reason is should be documented, but it needs to be short and sweet. Don't go into a whole long 3-page letter about, first we found out that this happened, then we looked into this, and so said that. You don't want to be providing all that information, right? The employee is not entitled to know who ratted them out or who gave this information that you're basing the separation on. You have done your investigation. You've based it on objective criteria and information. They're not entitled now to go on a revenge hunt against the people that may have released this information or told them this information. But the written confirmation should confirm the date that their separation is effective, what it was for, and then you'll need to provide, if you have health insurance, you need to provide a separate notice of their COBRA rights and things like that. And we could provide you with more information offline with respect to that response, but don't go into a whole long narrative about the basis. The last topic I have here is unexpected events or consequences. If you've been an employer long enough, you've had the situation where the employee that you're separating loses it, starts throwing things, freaking out, yelling, screaming, arguing with you, threatening you, those types of things. Don't get sucked into that. Don't get sucked into their debating with you that the reason they're being separated is right or wrong, or they have just say this, the rest of this meeting's not being productive. We're going to end this now. You need to leave, please. And just try to diffuse the situation and have them leave. I've only once had to call for security to have someone escorted out, but you want to try to avoid that if you can. That's why I always make sure that I'm sitting by the door, the employee is sitting someplace else. That way I can make a quick exit and run away if I really had to. I mean, I'm kidding that I'm not, but that's what I say when you talk about where you're going to meet with the employee. Try to keep some of these potential things in mind, just to make sure that you're protecting your employees. If you're separating an employee because of violence or threats or fighting or things like that, I don't recommend separating the employee in person. I typically recommend separating that employee remotely, either through a Zoom meeting like this or through a phone call, because you do need to take into consideration the safety of the rest of your workforce. And again, we could talk about that offline, and I'm sure you all have read enough articles and seen enough news clips of how those things can go very wrong. So, do assess that if the reason you're separating someone is for that type of conduct or misconduct, we should say, you would want to opt not for an in-person separation.
Can I just also add that
Sure.
when you're having these types of conversations, these meetings to separate from employment, more often than not, the employee knows what's coming, right? They know that they've had performance issues, attendance issues. There was some sort of discrete event that was a terminable offense. I've seen a lot of employees in those situations. They often like to record those conversations, usually without telling the other people in the room that they're doing so, which in New Jersey is legal to do, although maybe not the most morally appropriate thing to do, to record someone without telling them. But just keep that in mind, that you might be being recorded during these meetings. So I would keep them concise, to the point, convey the necessary information, but beyond that, I would try to not, go too far astray from the issues at hand.
Yeah, that's great. That's great advice, Adam. We've seen that more and more, that the employee does record those meetings, and New Jersey is one-party consent state, so they don't have to tell you or ask your permission. So,
And it's so easy to do now. Everyone has a cell phone in their pocket that they can hit a button and they can record everything. So
yeah.
keep that in mind.
So with that, this was the short. We tried to keep it as concise as possible. I hope everybody enjoyed the presentation. We have a lot more that we could talk about. Some of these topics, we do a whole presentation just on the one slide. So we can go into more detail on some of these things. We wanted to give you a nice broad overview of some of the most common issues that we're seeing, and hopefully how you can avoid being sued. Thank you.
Well, thank you all. Eileen, Adam, Lauren, any questions that weren't answered in the chat? I know, I had one real quick. Are you aware of any new regulations coming down the road, either state or federally, that, people should be aware of?
Yes, Lauren and I actually just did a presentation on this recently. So let's see, there is the independent contractor issue, and could be that maybe, let's see what happens with that. So that's a proposed regulation. It has to do with really formalizing the legal interpretation of the ABC test as to who is and is not an independent contractor. So that is one that we're closely watching. And if that does get passed and is going to be the new regulation, I think it would make sense for us to do a whole separate presentation just on that.
Right.
But that is something that we're watching. I know that they're expanding, they're looking to maybe expand some of the definitions for protected classifications in New Jersey. One that they were looking at was protecting discrimination on the basis of height or weight. I know that was one of them. Lauren, I think there was another one for that had to do with protected leave after miscarriage. Am I remembering that correctly?
Correct. Miscarriage, the death of a child, or the fertility treatments.
Okay.
Yes, there are a couple that we had been watching. There's a lot of talk about restrictive covenants, and that really has been coming under attack lately. And so there has been, over the last couple of years, a different proposed legislation to limit the use of and enforcement of restricted covenants. None of it has really gotten full traction yet. So again, it is on the horizon. I think that could have pretty seismic impacts. Laws that recently went into effect were in the last couple of years is the new New Jersey WARN, which kind of brings to New Jersey additional requirements than the federal WARN Act. So that's another one that we've lectured on in the past. But in terms of proposed legislation, Jane, they're the ones that I think we could keep an eye on. I think really the independent contractor one for sure would be one that could be helpful.
Yeah, and you're right. That's a lunch and learn in and of itself.
Yeah, as is the restricted covenant issue, but we'll keep an eye on that and see if there's any changes. Of course, anything we see newly enacted, we'll let you guys know, and happy to put together another presentation on it.
Yeah, terrific. We have a few more minutes if there are any questions from others. I think I added some of the questions that we had gotten prior to when people registered. But if there are any of those guests here today, feel free to put your question in the chat or raise your hand the old-fashioned way. Raise your hand. All right. Well, I want to thank you all very much, Fox Rothschild, Lauren, Adam, Eileen. This was our kickoff, our first in a series of what we're calling our Small Business Essentials webinar, Lunch and Learn series. They're really designed to help our small business owners, our family-owned, operated businesses who don't always have the opportunity to come out for a breakfast meeting or committee meeting, or can't always leave their business just to provide them with some real actionable, valuable information that could, as I said earlier, maybe prevent, someone from making a costly mistake. Connect you with those experts that that you may need in the future to reach out to say, I think I might need I might need your help. Can we, set up a conversation? So if you need a legal legal expert, feel free, their contact information is on the slide. Feel free to reach out to Adam, Eileen, and Lauren. And we really appreciate you all being here this afternoon, kicking off our first of the series. We're going to have future ones. We did put a survey out requesting suggestions on others. I know I heard business insurance. I heard insurance matters quite often. We got also another survey response. Could you help us with tips on marketing and website development? So we've got lots of, another one was on the tax implications that were as a result of the one big beautiful bill that was passed by Congress earlier in the year. So we've got some sample topics coming up. So be sure to check your emails. And we look to see you at another Lunch and Learn series soon. So thanks all for joining us. Oh, and Danny Mack, a bookkeeping and accounting webinar for perfect. What a great idea. Oh, and we got thumbs up from Amy from California Partners Apartments. So thanks very much, everyone, for being here. And have a wonderful rest of your day. Take care.
Bye, Eileen.